Good afternoon, class. This is our session on unprotected speech. The subject is Comm 120, Laws on Communication and Media. At the previous sessions, we talked about protected speech. Clearly, what is within the protection of the law. Now, we have to clarify what would be outside or not protected by the law. Remember that in the case of Chavez versus Gonzalez, it has been clarified that freedom of speech is not absolute. In fact, this freedom is, as stated here, not an unbridled license that gives immunity for every possible use of language. Freedom of speech does not prevent the punishment of those who abuse it. The case of Chavez versus Gonzalez is very instructive because this is the case which actually comprehensively discusses freedom of speech and of the press. This is the case of the Garci tapes. Okay, there was a question about conversations between a man and a woman, allegedly the then president of the Philippines, Gloria Macapagal Arroyo, talking to a COMELEC commissioner. So, ang suspecha ng mga tao, pinag-uusapan nila yung eleksyon at rigged na, kumbaga, yung eleksyon. And syempre, nagkagulo sa Malacanang at dito sa mga secretaries ni Arroyo. And the Justice Secretary ordered an investigation. Okay. Kasi daw, the media organizations which aired the Garci tapes could be in possible violation of the wiretapping law, RA 4200. Pasok naman tong si NTC at sabi niya, nagbanta siya, press statement, na radio and television stations who will be airing the Garci tapes could be subject to suspension, revocation, or cancellation of their licenses or authorizations. Siyempre, mabigat na ah, pangyayari ito, could be tantamount even to censorship. To an extent, KBP worked with the NTC para kumbaga maali yung fears tungkol sa censorship. But then, private citizen Francisco Chavez, he's a lawyer, no? He nullified, as usual, yung mga magugulo. He filed a petition to nullify the acts or ipatanggal o ipawalang bisa yung mga acts, issuances, orders ng NTC at ni Gonzales. Kasi ang sabi nila, this is one, clearly a violation of the freedom of expression and the right to information. And second, more of procedurally, the NTC had no power to do so. Okay? To stop the radio stations or television stations from airing the Garci tapes. Anyway, in this case, natalo yung NTC kasi una, the Garci tapes as is, no, they have not been authenticated. So, hindi mo rin masabi talaga na si GMA yun o kaya si Garci yun. Kaya, sinong magrereklamo? Kumbaga, totoo ba to? Only when the Garci tapes are proven to have false information and then saka pwede daw yung restriction. Okay? Clearly, this is a content-based prior restraint. Okay? Remember that when we say content-based, kung ano yung laman. At ito, yun yung target nila. Okay? Dahil yung Garci tapes daw were talking sorry, involved the president and Garciliano. Yun yung tinatarget talaga. So, mas mataas yung standard ng court scrutiny because this is content-based. And then, there's another discussion, another part of the discussion about privacy. Kasi kung sinasabi ni Garciliano na na-violate ang kanyang privacy because of wiretapping, well, he should file a case against wiretapping and not have the NTC ban all airing of the Garci tapes. So ultimately, itong NTC, itong pagbabanta niya dun sa mga mag-air ng Garci tapes is unconstitutional because it is prior restraint na content-based pa on protected expression. So, it's nice to read perhaps Chavez versus Gonzalez in full because it really goes through the entire um, spectrum of ano ba yung allowable or um, sanctioned restrictions on speech. Now, let me just introduce, siguro, this is more like a um, concept map of how to look at unprotected speech. So I'm looking at it from 3 points. Actually, simply put, it would be 2 points. If there is personal harm or there is societal harm, okay? When we say an information or an expression is false or fraudulent, though, it could affect the personal interests or societal interests. So I put it separately. And then falling in between these um, possibilities no, of harm, yung ating i-discuss na unprotected speech. Defamation is false and fraudulent and at the same time targets or affects personal reputation. Commercial speech is punished or kumbaga, unprotected to some extent if it's false because it causes harm to society. And then you have a large group of speech that is being regulated or is validly being um, or validly not protected because it affects the person, it involves society um, in a disadvantageous or in negative manner. Okay. So let's first talk about defamatory speech. We'll be talking about libel more comprehensively at the next session. But here, I'm going to introduce to you the article in the revised penal code for libel and accordingly for slander. So libel as a crime also carries civil sanctions, meaning pwede kang makulong, pwede ka ring pagbayarin ng korte. Okay? The only difference between libel and slander is that libel is orally or verbally made. Okay? In the case of Sullivan versus Makashar, there is a particular note about libel as applied or against journalists. Dito, kinlarify na itong mga defamatory actions uh, actually could cause a chilling effect on media. Because when you file libel cases against journalists, because they did their work, it could constitute a warning in some sense to them na wag niyong gagawin. When you say chilling effect, yung tipong manlalamig ka na lang at instead of pushing ahead, wala, hindi mo na lang gagawin. So it's, in a way, the chilling effect is forced self-regulation. So tatahimik ka na lang kasi para walang gulo, kumbaga, or hindi ka madamay sa gulo. The elements of libel, which we'll discuss again at a later stage, but please look at it or please approach this already from a conceptual point of view. So first, there should be an imputation of a crime, vice, defect, act, omission, condition, status, or circumstance. Merong sinasabi tungkol sa tao na public, malicious, and it's directed against the person. So the person does not necessarily have to be a natural person, meaning tao, a human. It could also be against one who is dead, okay? But also it could be against a group of persons, a corporation. To be more particular, a juridical person is one that is an entity recognized by law. So to be technical about it, this would be corporation set up under the corporation code. Although in some instances, Yes, an agglomeration or a group of persons can also be considered a juridical person. So n- they're considered a person in this sense. Kasi syempre nga naman, groups of persons, an organization, etc., can or also enjoy a reputation. No? And then lastly, this imputation, this statement, tends to cause dishonor, discredit, or contempt of a person, or tends to blacken the memory of one who is dead. Now, if you think of it more closely, no, ano ba yung karapatan mo na bina-violate ng libel? No? Ano, ikaw ba ay, o ba, naapektuhan ba yung kalayaan mo, naapektuhan ba yung life mo, na ano? Parang hindi eh, no? Ang libel actually affects private reputation. But then the Constitution seems to appreciate this as property. Okay? Well, also of life and liberty, but more of property. It recognizes the value of reputation. That is why it is punished. Yung kumbaga yung objective ng libel is not to punish persons na who commit it for disturbance of public order, but rather because of the injury on the person. This is regardless of the effect on the public. Yung ano nito, yung pagkatao. Okay? Sabi nila the objective of libel laws, it's to encourage the victims. Di, syempre, pag kung ano nung sinasabi sa'yo, yung biktima, may puwedeng paraan para kumuha ng revenge, so to speak, or to exact justice kesa sa magsapukan sila, mag-away sila, o kung ano pang gawin nila sa isa't isa kapag may umaway sa kanya. Previously, these attacks on honor, mas honor 'to, 'di ba? They were penalized under the provisions during the time of the Spaniards, provisions on calumny and insults. During the American period, there was also, dito na na-introduce, there was a special law on libel. And then right now, the various definitions through the years for libel, calumny, insult, it is absorbed in our definition of libel. Okay. There is another phrase called seditious libel. Okay. But this will be discussed under another context. In the case of espuelas of incitement, kasi this is political and is uh, an attack or rather directed uh, to national security, not on personal reputation. So first, let's have the case of New York Times versus Sullivan, uh, which is very instructive with regard to defamatory imputation.
Freedom of speech has its limits. Those limits were tested in New York Times Company versus Sullivan. In 1960, a civil rights organization took out a full-page advertisement in the New York Times. The advertisement detailed a, quote, wave of terror, unquote, perpetrated by civil rights opponents. Amongst other horrors, the advertisement accused the Alabama Police Department of terrorizing student protesters.
Okay, sorry for that. Okay, again. In the case of New York Times versus Sullivan, it's clear, no, it established the Sullivan standard. Clear that if media were to make defamatory statements or, kumbaga, bad things about a public official, hindi ka agad-agad sila masasampahan ng kasong libel. The complainant must still prove or establish that there was actual malice, na alam talaga niyang mali. Kaya dito na papasok yung mga possible defenses because, well, truth can be a defense. There was no actual malice because I know what I said was true. Only if I knew it was false. Tapos talagang sinabi ko pa rin na magnanakaw siya kahit alam kong acquitted na siya, saka lang papasok yung libel. In the video, you saw that it applies to public figures and not to private individuals, but, sorry, public officials. But this was extended to, ito na, public figures. In the case of Curtis versus Butts, the the person involved here was a football coach. And ako, sa US, di ba? Bonggang-bongga ang football coach. Para silang basketball coach dito sa Pilipinas. So, they were covered under the public official or public figure doctrine. So, kailangan ma-prove din yung actual malice when you contest them. Now, let's see the case of Lopez versus Court of Appeals. In this case, Manila Chronicle, they published a front page news story about Fidel Cruz, a sanitary inspector in the Babuyan Islands, who allegedly sent a disaster signal through a US Air Force plane. So parang SOS, SOS. So itong mga Amerikano, naglaglag ng radyo. So malayo ito, Babuyan Islands, ano. Itong si Cruz, sabi niya, may mamamatay tao na nagkalat sa may Babuyan Islands. So, syempre, una, i-rescue siya at pinuntahan para itong mga scout rangers ay i-check kung at hanapin itong killer na ito. It turns out it was a hoax. So, they called it the Kalayan hoax. Ah, so, lalong, actually, yung gusto lang pala nitong Cruz ay makauwi ng main island. So, free ride home. Now, kinover itong hoax of the year. Okay, layer by layer. So, may nangyaring kababalaghan na nakakatawa. Yung This Week, another publication, it covered this, sabi nila, hoax of the year. Okay? Kaso yung picture ni Fidel Cruz. So, para siyang sanitary inspector, kumbaga, head o siya mismo yung basurero dito sa lugar na 'to. Ang picture na nailagay nila kay Mayor Fidel Cruz. Pero binawi naman nila. Later on, they published a retraction, but nevertheless, Mayor Cruz sued for damages. Now, in the RTC, they found that it was correct. Cruz should be awarded damages. Kaso sa Court of Appeals, well, sa Court of Appeals affirmed. Kaso nung inakyat sa Supreme Court, binabaan yung damages. What's important to us would be photos is still speech, 'di ba? And it's covered by libel. And now when you apply the actual malice standard, medyo hindi uubra na hindi pala nag-fact check itong this weekly publication. Ang sinasabi din kasi na although mataas, no, sa hierarchy of rights, mataas ang pagtingin dun sa freedom of the press, and then also mistakes can be attributed to the daily stress of publishing. Still, meron siyang standards na kailangang abutin, ano. And then secondly, yung point about retraction. So, if you publish a false news or libelous information, even if you retract it, nagawa na yung damage has been done, eh, 'di ba? Meron ng damage to the reputation. And therefore, the retraction cannot erase the mistake. It can only It will not absolve you from pecuniary liability, pecuniary meaning monetary, and thus there can only be a reduction in the damages awarded. Okay. In the case of, sige, our next case would be Sullivan versus Makashar, which was earlier annotated, no? Pero in Sullivan Makashar, this was the libel case against Luis Beltran. He wrote in the Philippine Star that the then president, Corazon Aquino, hid under the bed during a coup attempt, December 1989. This is a quite a short case, no? Pero the RTC, they issued a warrant kasi sabi nila, yes, this is libelous. When this was questioned, the Supreme Court later on said, citing procedural grounds, that this was an improperly issued warrant. There were other issues, of course. First, whether the president can sue or be sued. And it was pointed out here that yes, 'di ba, medyo na-mention no sa balita yung presidential immunity. Habang presidente ang presidente, wag natin siyang galawin, wag natin siyang guluhin ng mga kumbaga frivolous or um pa, pa mag-immobilize sa kanya bilang government official sa paggampanan ng kanyang trabaho. Kaya merong tinatawag ng immunity. But the president can waive immunity. And second, ah yung immunity is only when the president is an accused. In this case, the president is a complainant. Nevertheless, ang important part about the Louis Beltran case is that libel is actually against freedom of the press, although the court did not rule on it fully, no? At sabi nila, this is a matter best left to the trial court. But it did mention about the chilling effect that when libel is filed against journalists or media publications, clearly it goes against um, the principle or the privilege of the press as purveyors of information in our society. Okay. So, but then let's see. No? So, ganun daw yung effect niya sa media. In the case of Arafiles versus Philippine journalists, in this case, there was a reporter of People's Journal Tonight who wrote about the forcible abduction with rape. And then another case na forcible abduction with attempted rape tungkol sa isang direktor ng isang government agency. And this was based upon sworn statements at the police station, no? May tinamaan. So, ito si Dr. Alfiles, he was the appellant in this case, no? He filed a civil suit for damages under Article 33 of the Civil Code, which, kumbaga, is addressed towards constitutional rights. The RTC granted damages up to 1 million for him. Pero binaliktad to ng Court of Appeals na approved ng Supreme Court. And so we go into the doctrine of fair comment. Um, the case here says that the libelous work should be examined as a whole. So earlier we talked about this weekly, yung nag-publish ng picture. Yung pag-publish niya, you have to look at it how these newspapers or how these publications work. And as a whole, newspapers, they enjoy a large degree of discretion over the manner of presentation of the news article. At kayang-kaya niyang iikot, ispin yung storya, di ba? Maglagay lang siya ng direktor ng ganitong timbog sa kasong rape when actually the case is forcible abduction with rape. Pero true enough, it is rape, no? Magpalit lang ng isang word sa headline, parang mag-iiba na. And so we go into the concept of sensationalism. Baka pag kahit na ilagay mo rape, no? Una, hindi pa naman napapatunayan. And second, isang count of rape lang naman pala. Sabihin na natin, in this case, sabi ni Arafiles kasi yung portray sa kanya para naman siyang serial rapist. Grabe naman yung parang gano'n ang punto niya 'no. Eh, it turns out there was only one incident of rape as listed in the, police blotter. Ngayon, eto na mga tanong. Ah, so itong si Morales, remember that we already have the public, um, public figure doctrine, okay? Covered ba siya? Well, yes, of course. However, in this case, hindi naman kasi addressed towards his public duties. 'Di ba? Pagkatao niya 'to. Second, saan ba nakuha yung information? Sa isang public document, sa blotter. And this is, well, a document that can be open to the public. In fact, ito pa, hindi lang basta binase nung reporter yung balita dun sa blotter, narinig pa niya. Turns out he was at the police station when the victim came and gave her testimony. Kaya kumbaga more or less may personal information siya. In this case also, okay, back to the uh, yung public document, no, this becomes important because there is proof that this really happened, and these are official documents. And therefore, that ang defense nitong reporter is that there was no malice because I only published the information as appears on public documents. And so we segue to the doctrine of fair comment. Okay? In Borjal versus Court of Appeals, there was a businessman who served as a technical advisor to a congressman in the House of Representatives. Ngayon, sa isang hearing ng isang subcommittee doon sa House of Representatives, sabi nila, alam nyo, magandang pag-usapan na lang natin to sa isang conference. Ang pinag-uusapan nila tungkol kasi sa land transportation. So, ito mga um, tungkol sa ano to sa public transport, etc. So sabi nila pag-usapan na lang natin 'to. Naging offshoot ng discussion nila sa Congress ang magbuo or mag-call together ng First National Conference on Land Transportation. Pero their objective was to make a draft bill for long-term land transportation policy. So this person, this businessman who was a technical advisor, he became the executive director tapos nung conference. Then he wrote and signed solicitation letters, etc. Now, a few months later, merong whistleblower o parang nag-break scoop. A columnist, Borjal, he wrote about the anomalous activities of an organizer, quote unquote, of a conference without naming the person or the event. So, dahil medyo particular, parang feeling nitong si Wenceslas, oops, parang ako yan. So, he complained, he wrote to the Philippine Star where the article appeared. Tapos nag-complain din siya sa National Press Club for unethical conduct. And also, he filed a case for libel. And this is where we come in. When the case of libel was lodged before the Department of Justice, it was first dismissed. But later on, the reinstitute and then the action for libel or damages was taken cognizance of by the court. And in fact, the RTC convicted Borjal, the journalist, of libel, awarding 1 million in damages. When it was appealed before the Supreme Court, affirmed. Sabi nila, yes, there was libel, pero they reduced the value. And ano yung premise ng Court of Appeals when it was deciding on the case? They said that it was defamatory. In fact, the statements were self-proclaimed hero. Yan. A conference organization associate with shady deals. Tapos meron pa, thick face, makapalang mukha. Kasi nga, ito yung nagsusulisit, di ba? So sabi nila, these statements are defamatory. Was he named? Well, he might not have been named in as in pangalan niya, pero he was identifiable. There were a lot of details that pertain to the National Conference on Land Transportation. And sabi din ng CA, kung may issue si Borjal, he could have just called the attention of the House of Representatives to check the authority of Wenceslao. Remember that Wenceslao is not a government official. Siya lang ay technical advisor. Kaya masyadong OA, kumbaga. The Supreme Court, when it looked into the issue, it reversed entirely. So, hindi guilty si Borjal. At ang kanyang premise, doctrine of fair comment. Okay? Saying that, while it does look like uh, the libel case is has been established, merong identification, may defamatory imputation, etc. This could be covered by the doctrine of fair comment. And this means that this is privileged information. And although Borjal's comments were not exactly fair and true, they were made in good faith. So sabi nila, may civic duty pang sinasite itong Supreme Court. Another weakness that the Supreme Court pointed out is identifiability. Okay? Even if the person again was not named, no? Ang sabi niya, it must be that a third person, yun yung standard, a third person can name or identify the person. And in this case, um, although hindi exactly, they also put in, ang daming excuse lang sa Supreme Court, no? The public figure doctrine. Okay. If Wenceslas was considered a private citizen, remember then malice would have been presumed. Sinabihan ka lang ng masama, private citizen ka, nananahimik, presumed na malisyoso yung nagsasalita laban sa'yo. Pero, in relation to the public interest, to the doctrine of fair comment, remember that he was a technical advisor to a congressman. Tapos, yung objective pa ng ginagawa niya, itong First National Conference on Land Transportation, was imbued with public interest. And although the conference was of a public/private interest, mako-consider na rin siya na within the public figure doctrine. Kaya nung unang sinasabi ng Court of Appeals that malice should be presumed, sabi ng Supreme Court, actually, no. The actual malice should be alleged by Wenceslao. And again, actual malice means that uh, it was knowingly wrong and still the publication published it. In the case of Policarpio versus Manila, okay? Sorry, Manila Times. Yung presumption of malice was further discussed. Ang ultimately ang sinasabi dito is that malice is presumed except if it is, this is another exception, if it is privileged information. Okay. In this case, Attorney Policarpio, nako, isang abogado. So he was the executive secretary of the UNESCO National Commission. Okay. Meron siyang sinampang kaso. Meron siyang sinampang kaso laban sa isang employee. Okay? Parang hindi niya kasundo ito. Ngayon itong employee, kumounter sa kanya. Nag-file ng malversation and estafa laban kay Attorney Policarpio. Nagsampahan sila ng kaso. Yung employee, pinapatanggal niya. Tapos yung employee, nag-countersuit. Hindi, magnanakaw ka naman, tsaka estepador. Itong Saturday Mirror at saka the Daily Mirror, ang pagkakapublish nila dun sa nabalita nila, no? Ang pagkakapublish nila is that Policarpio was charged. Okay? Attorney Policarpio said na parang, wow, parang ang implication niyan, guilty na ako, parang ganon. Actually, nung nagkaungkatan, ang ano niya, una, kinakasuhan ako tungkol sa ang framework niya ay galit sa kanya yung empleyado kasi pinalayas niya. Ang malversation tsaka estafa, tungkol 'to sa mga stencils. Ang worth nung stencils na di umano ay nawawala o yun nga yung malversation ay ₱54 ang worth, okey. Yung falsification na sinasabi, tungkol naman daw sa isang trip na totoo naman. Nangyari yung trip pero parang kung ano man, may hindi napirmahang, punto. So, napakaliliit na bahagi kaya parang bakit gano'n naman na, parang charge na ako agad. And then also, ito pa, si yung yung investigation na hinihingi ng empleyado ay through the office of the president at first, ni hindi pa nga sa korte nakakarating yung kaso. Kaya parang si Attorney Policarpio dehadong-dehado naman na ako dito. Kaya pumunta siya ng courts. Now, initially the courts, hindi siya pinansin, dinismiss yung kaso niya. Later on, umakyat siya sa Supreme Court. Ang kaso niya ay civil damages lang, umakyat siya ng Supreme Court, sabi niya, "Well, actually entitled ka sa damages." Okay. Here, it is clarified that every defamatory imputation is presumed malicious. So, gano'n na kaagad 'yon. Except, ito na yung mga exceptions. Kanina 'di ba, we had this exception dun sa public figure doctrine or public official doctrine. Except ito naman, first, private communications, it's privileged, or B, a fair and true report, which is related to yung earlier nating diniscuss, the doctrine of fair comment, which should necessarily be a fair and true report. Okay, in this case kasi, yung title or yung headline ng article ay PCAC wraps Policarpio for fraud. Okay, imagine niyo, PCAC wraps. This is a presidential commission. Sabi nga sa um, office of the president lang nagka-file. Pero yung wraps, 'di ba, parang kaso kaagad 'yon. Kaya sabi niya masyadong mabigat. Nanalo dito si Attorney Policarpio. The Supreme Court eventually ordered damages for the interest of justice. Although again, kinlarify ng Supreme Court dito that um, newspapers have the discretion, but truth can still be a defense. If it's fair, true, and made in good faith, then pwede pang panindigan, kumbaga. Although of course, again, kaya nagkaroon siya ng parang sa damages dahil yung aspect na parang may malisyoso, 'di ba? Again, malice should be presumed, but then klaro, na wala pang complaint sa korte. Actually dun sa body ng article, talagang wala, nasa Office of the President pa lang siya nirereklamo. Pero ewan bakit nila nilagay na PCAC wraps Policarpio for fraud. And then dinagdag nila on an aside is that the retraction will not wipe out the defamatory imputation. Okay? We go now to offensive or fighting words. These are words by the very utterance inflict injury or tend to incite an immediate breach of peace. So, talagang mapanghamon. These are the words which would more or less tend to cause action that is violent or harmful to the public. Let's see the case of Schenck versus US, which is the case that discussed the clear and present danger test. Remember itong shouting fire in a crowded theater? So, let's have a video.
Americans can say anything, right? Some believe that the First Amendment provides an absolute protection for speech and expressive conduct. But that's simply not true. Certain limited types of speech and expression fall outside the scope of the amendment's protections. So, what isn't protected by the First Amendment? The United States Supreme Court addressed this issue in Schenck versus United States. During World War I, Charles Schenck and Elizabeth Bayer, two leaders of the Socialist Party in Philadelphia, distributed thousands of leaflets to men who were eligible to be drafted into the United States Armed Forces. The leaflets urged the men to peacefully oppose the draft by arguing that the 13th Amendment, which prohibits slavery and involuntary servitude,
In Chaplinsky versus New Hampshire, there was a person, Chaplinsky, Walter Chaplinsky, who was part of the Jehovah's Witness sect. So he used the sidewalk as a pulpit. He was preaching by the walk and by the sidewalk, and then saying that organized religion is a racket, walang kwenta yan, ganyan. At syempre naka-attract siya ng malaking audience, and he caused a scene. Now, when the police took Chaplinsky to the station, Chaplinsky verbally attacked the marshal. At ang tawag niya, "You damned fascist." Okay? And then another, quote unquote, "goddamn racketeer." Okay. Okay lang sana eh, in yung initial exercise niya of free speech. Kaso nung inaaway niya na yung marshal, he was charged for this with a statute that banned offensive speech directed at others in a public space. It punished calling another by an offensive or derisive name. Goddamn racketeer, damned fascist. So yun yung ano. Before the lower court, he was convicted. Sa superior court, nag-trial pa sila. He was convicted again. Sa state court, Supreme Court affirmed. Akyat siya ng United States Supreme Court, convicted again. So clearly what he said, all the courts found so wrong. And this is where they put in the concept of fighting words. These are words that inflict injury or tend to incite another to cause an immediate breach of peace. Okay. So in this case, the the courts actually they discussed parang two tiers. So there's protected speech, and on another tier, there's unprotected speech, which is our topic today. The unprotected would be the lewd, the obscene, the slanderous, the profane, and insulting or fighting words. At ito ang sinasabi nila, they have no social value, they do not contribute to the expression of ideas. And what is protected in banning or regulating um, fighting words? It's to protect the public peace. Kaya lang ito yung problema. Paano masasabing offensive ang isang bagay? At ito na, papasok tayo dun sa konsepto na ng men of common intelligence or reasonable standards of men na, kumbaga, of the average man. Ganyan. So, the definition of offensive is what would men of common intelligence would think is an insult and would cause an average, again, another common intelligence, an average addressee to fight. Okay. When this was raised to the court, the issue was actually as to whether the statute is narrowly drawn or limited to specific conduct. Okay. And this is where we come into contact with such laws or an analysis of laws kung paano sila nag apply. Laws cannot be so general so as hindi mo na alam kung anong gagawin. Okay? Naalala niyo yung previously we had an example. Sige, kumain kayo. Pero kumain kayo ng lechon, ganyan. Kumain kayo ng chicharon. Pagbalik ng nanay niyo, sabi ng nanay niyo, "Kumain kayo, sige magmeryenda kayo." Tapos pagbalik niya nagalit siya, "Eh, hindi ko naman sinabing kumain kayo ng kolesterol." Ay naku, gano'n. Eh, dapat ilinaw niyo. So, kumain kayo ng tama or kumain kayo ng healthy things. Yun yun naman sinabi nanay. So, ganun ang konsepto din sa lawmaking. Kailangan directed lang dun sa mali. Okay? And in this case, they said that the statute, remember that this statute in New Hampshire or bans offensive speech directed at others in a public space. Sabi nila, that's it. That's actually narrowly drawn. It attacks or it targets offensive or derisive words in public. Malinaw, no? In a public space. So, kung nasa private arena sila or residence, hindi naman yun paparusahan. Okay? So, ganon ang naging um, instruction, kumbaga, under Chaplinsky. In the next case of Cohen, we are confronted with um, with mura. Okay? So, offensive words or sabi nila offensive conduct. Kasi, in this case, Paul Robert Cohen, he wore a jacket that said, "Fuck the draft" to court. So, panahon din to ng Vietnam War. He was in court to testify as a defense witness. Ganon. Sinuot niya yung jacket niya, tinanggal naman niya pagpasok niya ng kwarto, ng courtroom. Tapos paglabas niya, sinuot niya ulit. Tapos wala siyang sinabi na hindi niya verbalize yon. Nevertheless, he was convicted for this case because he said, because the state said that there is a statute that bans malicious and willful disturbance of the peace or quiet by offensive conduct. Okay. And so we are confronted again with the concept or different differentiation between speech and conduct. When it was raised to the higher court, the Court of Appeals, they said, yeah, wearing a jacket saying fuck the draft is offensive conduct. It is behavior which has the tendency to provoke others to violence or to disturb the peace. When it was raised to the state Supreme Court, sabi nila, medyo hindi namin sure, kaya umakyat to sa US Supreme Court, sa Federal Supreme Court. And so, the US Supreme Court was confronted with the concept of expletives. Ano ba to? Is this fighting words? Ano ba yan? Now, the US Supreme Court reversed the conviction. Although it said that expletives are covered. Kumbaga, there are 2 points to expletives, no, sa mura. May emotive. It could be an expression of emotion. Ay, putya naman, no? O kaya, kung ano. And it could also be cognitive, na yung parang expression of ideas. Ay, putang ina, tama, nakalimutan ko yung ganito. Di ba? So, there's many layers to it. It depends on the context, on the yung pronunciation nito. And in fact, one of the justices said that one man's vulgarity is another man's lyric. Ah. And then also na-consider, no, yung he was in a courtroom, 'di ba? Uh this is clearly an area where the law should apply. Okay? Although sinabi naman nila there's no distinction, no? Kung nasaan ka man sa state, it applies wherever you are inside the state. But then ito na. Sabi dito sa kasong to, you cannot actually consider it a fighting word. Itong expletive na to. Because it was not directed at any specific hearer. Okay? Compared to our earlier cases, meron silang audience. They were performing or talking to an audience. In this regard, there was no individual who could be personally insulted. There was no provocation of a group. In fact, there was no showing that anyone who saw the jacket was incited or invited to be violent, no? At sabi, unless there is a compelling reason, this simple display of his emotions could not be considered a crime. Okay. But there is a justice who dissented, si Justice Blackmun. At sinabi niya na, actually, again, expletives, ito, it might not exactly be speech, just speech, it's conduct. At mas type niya na ibaba siya sa lower court. So, sabi, tingnan nyo nga kung baka naman merong na-insight dyan eh. Ah, kailangang malaman kung was there clear and present danger in wearing so. In the case of Lewis versus City of New Orleans, ito din may minura itong tao dito. Tapos, it was directed at the police. So sabi nila, is this opprobrious language? So ito yung sinabi sa batas. It punished obscene or opprobrious language. Sabi, it could be a form of fighting words. However, ang nangyari kasi dito, yung defendant natin, si Lewis, kinukuhanan, pinapatingnan ng at tinitingnan yung driver's license ng asawa niya. Tapos minura-mura niya yung pulis. So, sabi nila, naku, mahihirapan tayo sa ganitong klase ng batas which punishes opprobrious or obscene language kasi that is overly broad. Now, next, let's have a video of RAV versus St. Paul.
One morning in 1990, a teenager living in St. Paul, Minnesota, fashioned a cross from the legs of a chair. He then set the cross ablaze on the lawn of a black family that lived across the street. Though no words were uttered, his message of hate was clear to most observers. The teenager was prosecuted under St. Paul's bias motivated crime ordinance.
Okay, so it's clear that there are limitations now or restrictions kung paano ba masasabi mo na offensive yung speech or fighting words ba ito. And then, as was discussed in the RAV, okay, take note yung RAV, it's like, in this case, initials, kasi minor yung ano nito, yung na-charge. So, ano niya to, alias, ganyan. Hindi siya talaga fully named, okay? So, ano din dito, Chaplinsky should not apply because of content discrimination. Dito talagang klaro na it was based on content. Now, there's a related case, the Terminiello case versus the City of Chicago. Dito kasi may dating pare na, ewan ko anong nangyari dito, naging racist siya, naging anti-Jews, anti-Semite, and he gave a speech um, in an auditorium before a large audience. Now, he was charged with breach of peace. He was convicted in the trial court, in the Court of Appeals, pero he was reversed. The conviction was reversed in the U.S. Supreme Court because they said that the law in Chicago, which punishes misbehavior which violates the public peace and decorum. So, yun misbehavior which violates the public peace and decorum. This law is overbroad. So now we're confronted with the question of, so now how do we define which are fighting words? Paano na kapag may kaharap kang, lalo na ito, pag police officers, usually ganun yung statutes, no? So iba-iba yan per area. Pag may police na inaway ka, fighting words na ba yun? There are many other instances in the US, usually maraming ganung incidents, ano? Nung tinawag nila na yung police ay son of a bitch or sabi, fuck you all or this is bullshit. Mukhang hindi pa yun fighting word. Pero, ah, eto, on the other hand, may isang hubad na babae sa beach, tinawag mong ay whore, harlot, Jezebel. Sabi nila, fighting words yun. Kumbaga, it invites the nude woman, yung hubad na babae na yun, na kalabanin ka. O ito naman, pulis ulit. Tawagin mo siyang white racist motherfucker. Tapos sasabihin mo, sana mamatay na yung nanay mo. That's fighting words. Or another word, fucking asshole. Ganyan. Tapos duduraan mo yung police officer. Fighting words din yun. So, medyo may iba-iba. So, earlier, this is bullshit, son of a bitch, hindi daw fighting words. So, kailangan talagang ma-standardize at kailangang makita yung conduct on the ground as against police officers. Okay? Kasi sila yung kokontra, no? Malamang sa malamang, police officers yung kaharap nitong mga mag-iingay or will be breaching the peace. Sabi din ng ibang korte kasi that some police officers should be held to a higher standard than other people if angry speech is likely to lead to an immediate breach of the peace. So, if you're a police officer and you routinely hear these things, you should not be quick to think of it as an offense to you. If to the normal person, iba yon, dapat sa police may broadness of mind and um, prior experience siyang i-invoke. And so now we go to the cases of incitement. And this is one notch higher than fighting words. Kasi ang fighting words talagang, oh, labanan mo ko. Dito, hindi ikaw yung lalabanan, kundi you incite others to do something, which will be a threat to national security. And so we have the incitement provisions in the revised penal code for incitement to war, 118, incitement to rebellion and insurrection, 138, incitement to sedition, 142, and under the newly passed law, the Anti-Terrorism Act, incitement to terrorism. So, what you're just doing is you're inciting others to commit a criminal offense. You're not even necessarily part of the commission. Basta meron ka lang na engganyo, eh, you can be convicted for the very words that you said, not for conduct. So, dito medyo komplikado. There's another kumbaga, set of cases that would apply when the state is either at war or in distress, such as this one in the Espionage Act. So, when you are, actually, hindi naman ito talaga sa incitement, no? Pero these apply when um, meron kang ilalabas na impormasyon. So, just a note, this is Article 117 and the entire Espionage Act of 1941. So, talagang may premium or may concern talaga sa national security and public order kapag medyo sensitibo ang impormasyon. There's also Article 154. This is actually the false news or fake news provision, which applies to um, information na ilalabas mo or news that ilalabas mo that would endanger public order. Okay, or would encourage disobedience to the law. Ang mahirap lang talaga dito is it's so encompassing. In fact, publication of anonymous books or under false name books, that's a crime under Article 154 eh. So, kailangang ma-consider talaga ng bongga itong Article 154 before we make another law that punishes fake news. The thing is lang, there have been so far no crimes or I cannot really say no, pero there are no cases that have gone up to the Supreme Court on Article 154. Very few. at hindi pa instructive. So, if ever there have been cases, baka sa lower court lang, tapos hindi na inakyat pa. When we go back to the case of Burgos versus Chief of Staff, another aspect that has to be considered is about the policy of suppression. Okay. It was noted there that dapat walang ganong polisiya yung mga gobyerno natin. Na pigilan yung mga newspapers or any publication na magsalita kontra sa gobyerno o sa pulisiya nito o kung ano man. Yung non-conformity, yung hindi sumusunod sa agos. Because that would pose no clear and imminent danger to state security. Maliban na lang, syempre, kung merong endangerment of public order, etc. Yung sa kanina. Pero kung kunyari, I disagree with this, kunyari, tokhang policy, parang mali ito. You cannot you cannot penalize the publication. Now, we have the case of People versus Perez, which we earlier discussed. Remember that it involved initially parang libel case yung final sa kanya, pero later on, it was considered to be a violation of sedition laws. And again, sedition um, is targeted at speech against, well, the government of the United States or against the government of the Philippine Islands, which tend to disturb or obstruct any lawful officer in executing his office or in performing his duty, or which tends to instigate others to cabal or meet together for unlawful purposes, etc., etc. So, kumbaga, um, kumukontra sa gobyerno. Okay. So, yun yung diniscuss dito sa People Perez na may speech talaga na kung minsan targeted na magpabagsak, sabihin na natin, ng gobyerno, and it targets the existence of the state, the authority of the government, or general public peace. Now, the case of Espuelas. Now, it talks about sedition as well. Here, Oscar Espuelas. Isa din yung maingay na citizen na yan. Picture naman ng pinost niya. This was a case that was promulgated, I think, 1920s. And si Espuelas, he posed for a photograph which looked like he was hanging from a tree. And then he sent this plus a suicide note to newspapers. At ang itong sinasabi niya, actually, the suicide note is addressed to his wife and children. And here he says that I am ashamed of our government. I want you to teach your children to burn pictures of the state officials. I do not like the Rojas administration and tell Truman and Churchill that there are many Hitlers and Mussolinis in the Philippines. So, galit siya dun sa pamamalakad sa Pilipinas. Sa trial court, he was convicted. In the Court of Appeals, convicted. In the Supreme Court, convicted. So, negative ang ganitong klaseng statements. In fact, when he tried to argue that, well, it's a suicide note and it's not addressed to anybody. Sorry, it's not addressed to the general public. It's addressed to my wife and children. Eh, bakit mo pinadala sa media? Kaya, at klaro yung kanyang intention na this should cause anarchy and radicalism, di ba? Kasi, I am so ashamed, hayaan mo, kumbaga parang magpapakamatay ako. In this case, the court said that people can criticize government, but you have to be specific and constructive. Kumbaga, fumer comment ka. Hindi pwedeng basta-basta mo na lang parang kinokondemn yung entire government setup. On the whole, his words sought to sow the seeds of sedition and strife. Yan. At meron pang binabanggit dito kasi si Espuelas dun sa kanyang suicide note na is parang an implication na way on how to you free or rid the government of Rojas, President Rojas and his men. Sinabi niya kasi juez de cuchillo. So parang pinananawagan niya na um, magkaroon or i-execute nyo. I-EJK itong si Rojas at saka yung mga tao niya. Kaya this kind of statements, this kind of speech is unprotected. Let's see now the case of Brandenburg, which is important in relation to the Schenck case.
The First Amendment right to freedom of speech encompasses one of America's most divisive and hotly debated subjects: the advocacy of violence for political purposes.
And so we have the Brandenburg test. With these elements must lead to or be likely to lead to illegal activity, imminence, and then the speech is exactly intended to produce that activity, kumbaga, sinabi mo na kung ano yung dapat gawin. Of course, Brandenburg is quite controversial in the sense that, remember, this began with and protected the speech of a Ku Klux Klan leader rather. Nevertheless, it's clear now that it's Brandenburg that is um, operative. It has modified the clear and present danger test for unprotected speech, no? As well as the bad tendency test of Whitney versus California and Dennis versus US. In these cases, if there appears to be a tendency that the speech will produce danger or will be dangerous, then it will be banned or it will be um, sanctioned. I'd also like to put in the case of Regina versus Most. This is a case decided in the United Kingdom. So Regina, so hindi siya people of the Philippines. So Regina meaning the crown. In this case kasi, sinaunang kaso at sinasabi niya na parang, ito ang gawin nyo, ito ang mangyari. And the publication was not addressed to anyone na parang, kayo mga Pilipino or kayo mga mga Briton, gano'n. Wala, sinabi niya lang. In this case, it was decided that even if it was not addressed to anyone in particular, this could still be considered within the incitement framework. In the case of Force versus Facebook, this is directed towards, well, yeah, the social media platform Facebook. Sabi ng mga families and victims of Hamas, which is a Palestinian or Islamic resistance group, sabi nila, Facebook is providing a platform for Hamas to communicate or to proceed with plans, 'di ba? So, nakakasangkapan yung Facebook para mag-usap daw yung quote-unquote terorista. Now, this case was dismissed under technicality. It's under the Communications Act whether Facebook ba is considered a provider, parang ganon, or is it a private entity? Ano ba to? Anyway, yung material sa atin is that uh, una, the argument is that Facebook is openly allowing these groups to proliferate. They have failed to remove pages. Tapos, because of the algorithms, when you are interested in this particular topic, so if you are a possible or potential terrorist, you can be directed towards content or to individuals that advocate it. Well, sabi naman ng Facebook on the other hand, well, we prohibit content that support or praise terrorism, but we use AI. For those that are not auto-detected, we have a group, as in physical people who respond like a counterterrorism team. Now, ito yung mga tanong dyan. Is Facebook a publisher of third-party content? Eh, para lang naman siyang bulletin board doon nagpo-post yung mga tao. Uh, does it develop its own content or supply content? On these points, medyo nag-fail yung case na ito because Facebook cannot be thought of providing content by suggesting friends or suggesting content kasi yung algorithm niya, kasi the content is still provided by the users. Kaya medyo lusot siya dyan. Okay. The cases that I also noted here would be Shurek versus Turkey. Shurek is a publication naman. And similarly, nag-publish sila ng, well, in different cases, nag-publish sila ng letter to the editor, nag-publish sila ng interview. Can we be held liable? Okay ba yon? For incendiary speech na talagang ganito, walang kwenta ang gobyerno kaya kailangan nating mag-aklas. In these cases, mas yung reflection pa ay, in the context of things, do the articles seek to inform or to incite people to action? And so they decided differently in different contexts. May isang factor na did the publication edit the article? There's another factor na was the article published at a time na mataas yung nangyayaring kumbaga violence in the area, sinasabi nila kapag masyadong kunyari nag-aaklas na yung mga tao, hindi ka magpa-publish ng letter to the editor na kontra sa gobyerno pa. So may mga ganong considerations. Kaya the as I see it now, the courts are looking at, in a way, content providers or yung mga platforms where we as people are sharing our thoughts. And in that way, they can also be taken into the ambit of these incitement laws. We end our discussion on offensive words, defamatory action, and incitement at this point, generally political speech. And at the next session, we'll talk about obscenity or obscene speech and commercial speech. Thank you very much for tuning in. Ingat!